This is Barry Salma speaking for Claim School Incorporated's blog, Salma on Insurance. Today we're going to talk about why you must go to jail and not pass go after you plead guilty to insurance fraud, and why a fraudster must serve his time and lose his residence to pay restitution. Armando Valdes appealed his 60-month sentence for healthcare fraud after he pleaded guilty. Valdes's conviction and sentence arose out of his scheme to submit millions of dollars in fraudulent medical claims to United Healthcare and Blue Cross Blue Shield for intravenous infusions of Infliximab, an expensive immunosuppressive drug. These infusions, purportedly given to patients at Valdes's medical clinic, Gasiel Medical Services, were either not provided or were medically unnecessary. In the USA versus Armando Valdes, United States Court of Appeal for the 11th Circuit on December 19, 2023, disposed of the arguments asserted by Valdes. They started with his loss amount created by his fraud. Federal courts sentence convicted defendants based upon offense levels set by federal statutes. The sentences are increased with the amount of loss caused by the offense. In Valdes's case, his base offense level was increased by 22 levels because the district court found that the loss amount was $38 million, and thus more than the $25 million minimum set by the statute, Section 2B1.1, Pren B, Pren 1, Pren L, that provides that a defendant's base offense level is increased by 22 levels if the loss from the fraud offense was more than $25 million, but less than $65 million. Intended loss includes harm that would have been impossible or even unlikely to occur. Analyzing the situation, the court noted that Valdes did not show the 11th Circuit that the district court's loss amount of $38 million was clearly erroneous. Valdes admitted through Gasiel he submitted approximately $33 million in fraudulent claims to United Healthcare and approximately $5 million in fraudulent claims to Blue Cross Blue Shield. Even if United Healthcare was unlikely to reimburse Valdes for the entire amount billed, or for duplicate claims, those claims were nevertheless properly included in the intended loss amount. It was not what he got, but what he intended to receive from his fraud. At the sentencing hearing, Valdes's own fraud analyst testified that even accounting for duplicate claims, the total loss amount was above $25 million, the threshold for the 22-level increase in Valdes's offense level. If a defendant's fraud offense involves sophisticated means, his offense level is increased by 2 levels. Whether conduct is sophisticated is based on the conduct as a whole, not on the individual steps. The 11th Circuit reviewed a district court's factual findings for clear error and its application of the guideline provision to those facts. Since the 11th Circuit found no error in the district court's application of the 2-level sophisticated means enhancement, that part of the sentence was affirmed, and the 11th Circuit noted that Valdes operated an elaborate, years-long scheme to defraud insurance companies for expensive Infliximab infusions, obtaining over $7 million as a result. The large amount of money defrauded and the 6-year period the scheme went undetected supported a finding of sophisticated means, adding another 2 levels of enhancement. Valdes hid behind two licensed doctors, Hilario Isaba and Ramon Santiago, who claimed no interest in Gasiel and did not prescribe Infliximab. In light of these facts, the district court properly applied an extra 2-level sophisticated means enhancement. Valdes argued the district court erred by ordering the forfeiture of his home as a substitute property. Valdes admitted, however, that as part of his plea agreement, he agreed to forfeit his primary residence as substitute property. Valdes's statements made during the plea colloquy are taken by the court to be true. In these statements, Valdes acknowledged that he had read and understood his indictment and plea agreement. Because Valdes failed to show any plain error in the district court's accepting his guilty plea as to the forfeiture allegations, he has shown the district court did not err in ordering the forfeiture of his primary residence as substitute property. In essence, Valdes lost every claim of error he made. In my opinion, people who earn millions by defrauding health insurers find it difficult to believe they were found guilty of a crime and were required to serve time in jail and pay restitution to their victims. Valdes admitted his crime only to be so shocked by his sentence that he filed an appeal to eliminate or reduce the sentence to the crimes he admitted by asserting a plea of guilty. He wasted the time of the trial court on the 11th Circuit and should have been punished further for attempting the appeal. He was lucky that the 11th Circuit only affirmed the sentence and made him serve his full 5 years in prison. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll have access to the more than 4,900 blog postings. If you are interested, please tell your friends and colleagues about the blog and the videos so that they too can subscribe. I'd also appreciate it if you follow me on X, which was used to be called Twitter, and where you can also see the full blog postings. And if you're interested in further detail about insurance, insurance law, insurance claims, and insurance fraud, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.